Hi, this is Ishita, Dutta, a legal intern at LEXIS and Company, and today I will be talking about the concept of absolute liability. The concept of absolute liability evolved in India after the case of MC Mehta versus Union of India, famously known as the oleum gas leak case. This is one of the historic cases in the Indian judiciary. The case of MC Mehta is based on the principle of strict liability, but with no exception, and which given and the individual is made absolutely liable for his acts, and it is based under this principle that the defendant won't be allowed to plead defense if he or she was at fault, as it was laid down in Ryland and Fletcher's case. After the Bhopal gas leak case, many people lost their lives and are suffering from some of the fatal diseases through the generation, and because of this there was an urgent need to develop a rule under strict liability which had no exceptions available to the defendant to escape from liability. The rule laid down by the Honorable Supreme Court of India is much wider with respect to the rules laid down. The House of Lords in the case of Ryland versus Fletcher, it was propounded by the Supreme Court that where an enterprise is engaged in a hazardous or inherently dangerous activity, and if any harm results to anybody on the account of the accident in operation, the enterprise would be held strictly and absolutely liable to compensate to all those who are affected by the accident. So what are the essential elements of absolute liability? So the essential elements of absolute liability are as follows. First is dangerous thing. So as per the rules laid down, the liability of escape of a thing from an individual's land will arise only when the thing which is collected is a dangerous thing, that is a thing which is likely to cause damage or injury to other people in person or their property on its escape. In various tort cases which have happened all over the world, the doctrine of strict liability was held a large body of water, gas, electricity, vibration, sewage, flagpole, explosiveness, fumes, rusty wires are certain things which come under the ambit of dangerous things. So second is escape. Anything which has caused damage or mischief should have escaped from the area which was under the control of the defendant to come under the ambit of absolute liability. Like it happened in the case of Red versus Lions and Corporation, where the plaintiff was working as an employee in the defendant's company which was engaged in manufacturing shells. The accident happened while she was on her duty that day within the company's premise. It happened when a piece which was being manufactured there exploded, and due to which the plaintiff suffered harm. And after this, the incident, a case was filed against the defendant's company, but the court eventually let go the defendant and gave the verdict that the strict liability is not applicable here in this particular case, and this was declared by the court because the explosion that took place was within the defendant's premises and not outside. And the concept says that it should have escaped the dangerous thing like shell here from the boundaries of the defendant premise, which didn't happen and was missing over here. So the negligence on the part of the defendant could not be proved in the court. Third is non-natural use of land. Water collected on land for domestic purposes does not amount to non-natural use of land, but if one is storing it in large quantities like in a reservoir, as it was in the case of Ryland versus Fletcher, then it amounts to non-natural use of land. The difference between natural and non-natural use of land, by keeping in mind, is the surrounding social conditions. As the growing of trees and plants on land is considered as a natural use of land, but if one starts growing trees which are poisonous in nature, then it will be considered as non-natural use of land. If an issue arises between the defendant and the plaintiff, even though the defendant is using the land naturally, the court will not hold the defendant liable for his conduct. Fourth is mischief. To make the person liable under this principle, the plaintiff at first needs to show that the defendant had done the not natural use of land and escaped the dangerous thing which he has on his land, which resulted in the injury. And further, in the case of chairing case Electric Supply Corporation versus Hydraulic Power Corporation, the defendant was assigned to supply water for industrial works, but he was unable to keep their mains charged with the minimum pressure that was required, which led to the bursting of the pipeline at different places. This resulted in causing heavy damage to the plaintiff, which was proved in the court of law. The defendants were held liable in spite of this, that they were not at fault. These are the few rules where this doctrine is applied. So what is the scope of rule of absolute liability? To answer this, in most of the places, the rule of strict liability and absolute liability are seen as exceptions in the law, and the individual is held liable when he or she is at fault. But in such cases, the individual could be held guilty even if he is not at fault. After the catastrophic accident of the oleum gas leak case, the Act of the Public Liability Insurance Act 1991 was introduced with the main purpose of providing immediate relief to people who are victims of the accident in which handling of hazardous substances is involved. The agenda behind this act was that the act will create a public liability insurance fund which will eventually be used for the purpose of compensating the victims. Hazardous substance under this act is defined as any subject which by reason of its chemical or any properties is liable to cause any damage to human beings, other living creatures, plants, microorganisms and property or to the environment. The term handling is described in Section 2, Clause C of the Public Liability Insurance Act 1991, which is the clear expression of the rule of absolute liability laid down in MC Mehta versus Union of India. So the question is now, is strict liability and absolute liability the same thing? No, strict liability and absolute liability are not the same things and are completely different. As in strict liability, the defendant has the chance to escape the liability after causing the damage and injury, whereas under absolute liability, this is not the case, as the defendant is held absolutely liable for his acts. This means that even if both the rules come up for giving punishments to the wrongdoer who has caused injury and by dealing with hazardous substance without proper care and caution, but they would differ in cases of providing relaxation. As in strict liability, there are some defenses which are available to the wrongdoer, but in the case of absolute liability, there are no defenses which are available and given to the defendant. It was even declared by the courts that absolute liability could even be upheld in the case of single death, and there is no need for any mass destruction or pollution done to the environment. So by analyzing the need to modify the 19th century rule of strict liability, the apex court in MC Mehta versus Union of India stated that moreover that the principle which was established in Ryland versus Fletcher's case cannot be applied in the modern world because the rule was laid down in the old world as compared to the one laid down in the modern world, which is period of industrial revolution, and this principle is 2 centuries old, which can't be adopted without the modification being made into it. The main aim is to limit the scope of the rule and bring it at the same level as the modern theory. So what is the evolution of absolute liability? The rule of absolute liability has evolved as a result of the old rule, and it can't be applied in Indian law perspective as it is inappropriate for the reason because its evolution is because of high industrial growth or agricultural use of land, etc. We all know that India is a developing country, and with that it is a developing economy too. And the doctrine of strict liability is a very old principle. The old rule evolved when there was a low or limited scope for industrial development compared to today's scenario where there is high in industrial growth and the economy. So absolute liability is strict liability minus the exceptions. The scope of the rule of absolute liability is very wide in all its aspects when compared with the old rule, as it does not have any exception laid down under the new rule. Not only it covers public negligence or fault, but it also even covers personal injuries caused due to the misconduct of the neighbor. Now it covers not only the one who occupies the land, but also makes people liable who is not the owner of the land. Absolute liability has been brought up in the case of MC Mehta versus Union of India. Also, this is one of the landmark judgment in India's legal history. The rule which was laid down after this case was that any enterprise which is engaged in any kind of hazardous or inherently dangerous material, which if there might result in any kind of harm, then the enterprise would be absolutely liable to compensate to all the people who are affected by the same. It also happened in the Bhopal gas tragedy case. The facts of the case go on like this, that in the city of Delhi in 1985, there was a severe leakage of oleum gas in the month of December 1985. This incident took place in one of the units of Shriram Food and Fertilizers Industries, which belonged to the Delhi Cloth Mills Limited. As a result of the accident, an advocate in the Tis Hazari court had died because of the poisonous fumes, and many others were severely harmed. This incident led to the filing of a PIL in the courts in India. So the PIL is filed by a group of individual or by any person in the Supreme Court or High Court of India, and PIL is the tool to armor public interest, and this instrument is brought by the court and not by the aggrieved party, but it is brought by the court of law. or by any private party other than aggrieved party in the society. It was in SP Gupta versus Union of India that the Supreme Court of India has defined PIL in its elaborate form. The traditional rule of locus standi that held that a person whose right is infringed alone could file a PIL has now been removed by the Supreme Court in its decision over the period of time, like as declared in Badua Mukti Morcha versus Union of India. So, and also the Parmanand Katara versus Union of India and many more. Now, any public spirited citizen has all the rights and can approach the court for the public cause by filing a PIL in the Supreme Court of India under Article 32 and High Court under Article 226 even could be filed by approaching the Court of Magistrate under Section 133 of CRPC. For example, a construction company was constructing highways as per the orders, and for doing this, it has to blast rocks with dynamite. The company carried out this activity with extra precaution and care, and in spite of this, some fragments of rock had flown and damaged the neighboring houses. So as a result of this, the owner of the house sued the company for the damage they had caused by their act, but the corporation raised an argument in the court that they cannot be sued because they are free from the fault, but this was not upheld by the court and they were held absolutely liable for their wrongful acts, and it is no defense that they took extra care and precautions to prevent the harm which had caused. A tort is a civil wrong for which the remedy is an action taken by law for the unliquidated damage, which is not exclusively breach of any contract or promise or any other kind of obligations. There are principles in law which only hold a person liable when he or she is at fault, whereas in certain principles, the individual is held liable without him being at fault. This is the no-fault liability principle. This no-fault liability principle has two main landmark judgments, Ryland versus Fletcher, strict liability, and MC Mehta versus Union of India. In both these cases, the individual was made liable even though he was not responsible for the damage caused. Thank you.